Dictation will start in 5 seconds. Start. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications, or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of list of successful candidates for appointment. The doctrine proscribing change of rules midway through the game or after the game is played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an equality enshrined in Article 14. In other words, Article 14 is the genus while Article 16 is a species. Article 16 gives effect to the concept of equality in all matters relating to public employment. These two articles strike at arbitrariness in state action and ensure fairness and equality of treatment. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Recruiting bodies subject to the extant rules may devise appropriate procedure for bringing their recruitment process to its logical end provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Procedure prescribed in the extant rule cannot be violated. Extant rules having statutory force are binding on the recruiting body both in terms of procedure and eligibility. Where there are no rules or the rules are silent on the subject, administrative instructions may be issued to supplement and fill in the gaps in the rules. In that event, administrative instructions would govern the field provided they are not ultra vires the provisions of the rules or the statute or the constitution. But where the rules expressly or impliedly cover the field, the recruiting body would have to abide by the rules. Appointment may be denied even after placement in select list. A candidate placed in the select list gets no indefeasible right to be appointed even if vacancies are available. But there is a caveat. The state or its instrumentality cannot arbitrarily deny appointment to a selected candidate. Therefore, when a challenge is laid to state's action in respect of denying appointment to a selected candidate, the burden is on the state to justify its decision for not making appointment from the select list. Candidates participating in a recruitment process have legitimate expectation that the process of selection will be fair and non-arbitrary. The basis of doctrine of legitimate expectation in public law is founded on the principles of fairness and non-arbitrariness in government dealings with individuals. However, the doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. The public authority has the discretion to exercise the full range of choices available within its executive power. The public authority often has to take into consideration diverse factors, concerns, and interests before arriving at a particular policy decision. The courts are generally cautious in interfering with the bona fide decision of public authorities which denies legitimate expectation provided such a decision is taken in the larger public interest. Thus, public interest serves as a limitation on the application of the doctrine of legitimate expectation. Courts have to determine whether the public interest is compelling and sufficient to outweigh the legitimate expectation of the claimant. A three-judge bench of this court, while accepting the salutary principle that once the recruitment process commences, the state or its instrumentality cannot tinker with the rules of the game insofar as the prescription of eligibility criteria is concerned, wondered whether there should apply also to the procedure of selection. In that context, doubting the correctness of a coordinate bench decision in K. Manjusri for not having noticed an earlier decision in Subhash Chandra Marwa wide order dated 20 March 2013, it was directed that the matter be placed before the Chief Justice for constituting a larger bench for an authoritative pronouncement on the subject. The Rajasthan High Court wide notification dated 17 September 2009 invited applications from amongst judicial assistants and junior judicial assistants having an experience of 3 years in the establishment of the High Court and possessing degree of MA in English Literature for appointment on 13 posts of translators. Preference was to be accorded to law graduates. Stop.